Today's video is going to be what the author Stephen Heyman refers to as the transformation of free speech theory. What did it look like before? How are people interpreting free speech now? Free speech is limited by the fundamental rights of others, and laws may protect these rights against speech that violates them. So we view the First Amendment issues in terms of opposition between freedom of speech and state interests. This is according to the author. During the late 19th and early 20th centuries, the theory of natural rights gave way to a more positivist and utilitarian conception of law. Now, in a previous video in this series, we defined legal positivism and utilitarianism, and I'm going to define those again. First, legal positivism is the thesis that the existence and content of law depends on social facts and not on its merits. The positivist thesis does not say that law's merits are unintelligible, unimportant, or peripheral to the philosophy of law. It says that they do not determine whether laws or legal systems exist. The fact that a policy would be just, wise, efficient, or prudent is never sufficient reason for thinking that is actually the law, and the fact that it is unjust, unwise, inefficient, or imprudent is never sufficient reason for doubting it. So just because something would make sense doesn't mean it's actually the law that we have to follow. And just because something doesn't make sense or seems unfair doesn't mean that the law doesn't exist. Utilitarianism is generally held to be the view that the morally right action is the action that produces the most good. Who defines morals? Who defines most good? Who knows? The law was not to protect the rights of individuals, but to promote social good. That is a big, big shift in beliefs. That the laws were not to protect our freedoms that we felt were naturally given to us, but to promote social good. Oliver Wendell Holmes Jr. was a Supreme Court justice, and he had some things to say on this. He viewed our natural rights as a threat to social order. He insisted that the legal and constitutional interpretation should be divorced from ideas of the rights of man in a moral sense. He said that our rights do not have an independent existence, that they got their force from positive law, which promoted social ends. He viewed legal disputes as clashes of social interests that should be resolved by weighing considerations of social advantage. What is social advantage? Who defines this? What are the implications of this? Views like Holmes' views undermined the American rationale for freedom of expression. It's very, very different from what people in the 1700s were saying about our rights. That free speech was just another right to be weighed against all other rights. It was not entitled to special protection. In the case Schenck versus the United States, it was the Supreme Court's first effort to address the meaning of the First Amendment, to flesh it out. Justice Holmes conceded that individuals have a right to express their views. That was nice of him. But the right did not protect speech that endangered other social interests. There's that term again. Justice Holmes said that the question in every case is whether the words are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. So who has the right to decide what constitutes, as he said, a clear and present danger? What does that mean? He said the standard was satisfied when speech has a tendency to cause social harm. So who decides what social harm is? Who has the right to decide that? And what is social harm to one group of people versus a different group of people? The rejection of natural rights threatened to undermine the constitutional basis for protecting free speech. Earlier Americans had viewed our rights as natural rights to be protected by laws, but people like Holmes were saying, nope, there is no basis for this. Holmes also said in the case called Abrams versus United States that when expressions of opinions threaten important social objectives, suppression of the right of expression appears to be a perfectly logical response. Does that seem logical to you? Social objectives? What social objectives? Why do they get to trample on people's right to express their own thoughts and viewpoints? And how are we seeing this play out today? Holmes, according to Stephen Hayman, laid the foundations of modern free speech jurisprudence on the ruins of natural rights theory. He did not view rights the same way that some of the English had and some of the early Americans had at all. He interpreted it completely differently, that social interests are superior, or at least that they can be superior. That is an overview of how Americans changed their views over the centuries about natural rights, about what's the most important thing in the law. Next time, we'll continue the look at the old way of viewing things and the newer way of viewing things about our rights.